Good afternoon, everyone. It is an honor to felicitate our august guests and dignitaries on this auspicious occasion. We honor, celebrate, and applaud the achievements of our esteemed guests. It was a very eventful and very proud day for Dr. Ambedkar Law College. We hosted the National Moot Court Competition 2024. It was the first time this college ever hosted national level moot court competition, and it was an exhilarating experience for all of us. Moot court is the vital link between legal practice and legal theory. We have successfully completed the preliminary rounds, and soon we will be plunging into the semi-finals and the finals. I would like to extend a warm and heartfelt welcome to our distinguished guests. We are privileged to have you amongst us today, and we thank you for taking out time from your busy schedules to extend your support and blessings. We welcome our luminaries on the dais. Chief Guest, Honorable Justice Jitendra Jain, Chairman, Honorable Anandraj Ambedkar, Secretary, Honorable Sanjeev Bodhankar, Principal Ma'am, Dr. Yashodhara Wadala, Kaka Sahib Ghambalkar. Now, I'll request Chairman Anandraj Ambedkar sir to welcome our Chief Guest, Justice Jitendra Jain. Thank you, sir. I'll request Principal Ma'am. I'll request Principal Ma'am to welcome Chairman Anandraj Ambedkar sir. I'll request ma'am again to honor Secretary Sanjeev Bodhankar sir. I request ma'am to felicitate Kaka Sahib Kambadkar sir.
Thank you.
I request Chairman Anandraj Ambedkar sir to felicitate our principal, Dr. Mrs. Wadala. Thank you, sir. I'll request Ganesh Jangam to welcome Advocate Kemas K.T. Kerawala, sir.
Good afternoon, everyone. We are delighted to have such a great personalities among us. Good afternoon once again. We are delighted to have such a great personalities among us. Their esteemed presence has indeed glorified the event and added that vibrancy to our humble gathering. It would be our fortune to grab some words from all of you. Hence, I would like to call our Chairman Sir Anandraj Ambedkar to share some words of wisdom with us. Sir is a social activist, engineer, and renowned politician from Maharashtra. He is the head of Republican Sena. He has very proud lineage. He is the grandson of Bharat Ratna Dr. Babasaheb Ambedkar, who is the father of our Indian Constitution. He and his supporters were instrumental in demanding Statue of Equality Memorial of Dr. Babasaheb Ambedkar. Anandraj sir also works for the Vanchit Bahujan Aghadi, headed by his elder brother, Honorable Prakash Ambedkar Sahib. We are blessed to have you today, sir. I would like you to request to share some words of wisdom with us.
Good afternoon, everybody. Respected Honorable Justice Jitendra Jain sir from Bombay High Court, and my colleague Sajid Wadala, the principal of this college, Dr. Wadala, and other honorable advocate Kerawala, and you all other people, all other students. Today it's a day for you all students to have a practice, sort of practice session, because in future you are going to take part into a legal faculty and how it operates, how this practical this court matters and how it works. That will be this today's Moot court will give you experience about it, and this sort of exercise we are doing in all of our colleges of law. There's in Siddharth College here, in Ambedkar College, and other in Aurangabad also. And we are trying to give exact experience of what is happening in the court. And I'm very glad and I'm very much thankful to Honorable Justice Jitendra Jain, because so much work these people have got. I just talked to him. So he said, as per international standards, for Mumbai High Court, we should have 2,000 judges, but we have got only 60. And we are trying to cater all these cases. So it's a great work these people are doing, and out of which he has spending some time with us. It's a great. I'm personally thanking him, and I'm thanking everybody. I'm not going to take more time for you because he's going to give you more guidance about what is happening in actual court. So I thank you, everybody, and thanks especially to Honorable Judge Jain. Thank you all.
I request student Jayashree More to present a bouquet to Professor Oza sir. We thank the dignitaries for honoring us. Now we start with the semi-finals.
Okay, now it's semi-finals start.
Good afternoon. Good afternoon, each one of you. Welcome to the semi-finals of the National Moot Competition 2024 under the auspices of People's Education Society, Dr. Ambedkar College of Law. The will to win is important, but so is the will to prepare and perform, which is even more vital. Today, we have 16 teams participating in the Moot competition. 4 teams have reached the semi-finals. With your permission, sir, the teams which have reached the semi-finals are team number 15, 09, 01, and 14. To preside over the semi-final rounds and the final round, we are honored to have with us our chief guest, Honorable Justice Jitendra Jain from Bombay High Court. Justice Jitendra Jain, sir, did his schooling at Mumbai and completed his BCom from Jain College, Mumbai. He obtained his LLB from Government Law College. He is a qualified chartered accountant, cost accountant, and also completed his company secretary course. He is secured 34th rank in ICWA final exam and also obtained the highest marks in interpretation of statutes at the 3rd year law examination. He has been in counsel practice since 1997. He is from the chambers of Sri Rafiq Dada, civil advocate. He also practiced in direct and indirect taxes, fiscal, economic, corporate and constitutional laws. He has appeared before the Honorable Supreme Court of India, Honorable Bombay High Court and its benches, and had an occasion to appear in most of the high courts across the country. He has also appeared before the direct and indirect tax tribunals at Mumbai, Chennai, Hyderabad, Pune, Goa, etc. He has taught taxation laws to students appearing for cost accountancy, chartered accountancy courses. He has written various articles in several newspapers, magazines on fiscal and economic laws, given lectures, presentations at various seminars, and so his sole emphasis is on simplification of fiscal and economic laws to chartered accountants, students, and to the common man. He has contributed to various research papers too, and has authored a book based on Maharashtra Protection of Interest of Depositors Act, MPID Act. His accolades are innumerable and truly awe-inspiring. We are honored by his presence to preside over the semi-finals. I call upon the first name with your permission. The appellant will be 01 team and the respondents will be 09. I request the teams to please take their positions. 01 appellant and 09 respondent. One and 09 teams, please occupy your positions. Please come forward. The teams may please check their mics and submit case laws or relevant documents to the chair. Already submitted. I seek your kind permission, Your Honor, Your Lordship, to start with the session. Thank you.
Good afternoon, Your Honor. The council seeks permission to address the bench as your lordship. The council is appearing before the court in the matter of state current on behalf of the other under Article 136 of Constitution of India, which states the special leave appeal to investigate Honorable Supreme Court. Your lordship if your lordship is aware of the facts of the case, we shall proceed with the proceeding.
You have to just tell me in brief what are the facts.
So in this matter, the victim Jessica, who is a 12th grade student, who was then resident, as well as gifted Jessica an expensive watch, which was accepted by the victim unknowingly. On February 14, 2022, Jessica was proposed by Kevin for marriage. Afraid of whatever the reasons were, Jessica told the accused to contact her parents or ask their permission. But the parents rejected, however, and the accused, who was Kevin, he constantly approached her and requested her to accept the proposal, but she stayed firm and rejected him every time. But at some time, the persistent approach was escalated so much that she actually had to inform her parents once again. The parents confronted him, and the situation escalated so much that a fight occurred where the accused was beaten up. Later, agreed he went to his friends. There were 3 other accused who later absconded, but they were convicted in the second court. During the High Court, Kevin, the sole appellate here, appealed for acquittal, and the High Court proceeded and reversed the judgment that was passed by the Honorable Sessions Court, where the accused was convicted of the crimes, multiple crimes.
On what grounds the High Court reversed the order of the session?
So, in the High Court, it was held that the Sessions Court had wrongly held the accused liable under Section 326A, 26A, which is for the previous reading the affidavit, and by quoting Section 34, which is a common intention, as no common intention to commit the offence of acid act under Section 26A could be proved. The High Court also held that the offence of stalking under Section 354B of IPC was not made out against the accused either. But the High Court, however, recommended the State Legal Services Authority to decide upon the quantum of compensation that would be awarded by the state government to the victim, as per Section 370.
So what is wrong in the order of the High Court you have to tell me?
So we have some major issues that we have started on the commission. There are 5 main issues. First, whether the appeal is maintainable or not. Issue number 2 is the High Court justified in acquitting the accused of the charges of stalking. And issue number 3, whether there exists common intention between Kevin and the other 3 accused as per section 34 of the IPC. Issue number 4, by transferring the case for consideration of enhancement of compensation and acquitting the accused, is it setting a precedent of blood money in the country? And issue number 5, is the state justified in its plea to add 366 of IPC in the appeal of the Honorable Supreme Court? Myself would be, I would be dealing with issue number 1 and 2, and my co-counsel would be dealing with the further 3 issues. If the counsel is in the first issue, it is whether the appeal is maintainable or not. It is submitted that the appeal is maintainable under section 136 of Constitution of India. The appeal satisfies the requisite legal and procedural standards that are required for a particular appeal. In the present case, the Honorable High Court had reversed the conviction against the accused Kevin that was made by the.
You can go to the next one.
Sure. In the issue 2, it was said that whether the High Court is justified in acquitting the accused of the charges of stalking. It submitted that the High Court did not, the acquittal of the charges of stalking by the High Court was not justified because there are mere reading of the provisions that are stated in the section 354 of the law of stalking. It is in the subsection 1 of clause 1. It is stated that any man who follows a woman and contacts or attempts to contact a woman to foster personal interaction repeatedly, despite a clear indication of disinterest by such woman, shall be convicted under the same.
What was the finding on this issue of the High Court on stalking?
There was no specific mention of it in detail, but the only thing that they said that the offense of stalking was not made out against the accused, that is correct. But in the facts of the case,
They did not give the reason as to why the You can go to the next one.
for the
Issue number 3.
my co-counsel will for it. Thank you.
The council seeks permission from address the Minister of Project. So now reading the issue 3, which is whether there exists common intention between Kevin and the other 3 accused as per section 34 of IPC. So the council were apparently submits that the common intention exists between Kevin and the other 3 accused as per section 34 of IPC. So for attracting the purposes of section 34, there must be possible common intention. Then nextly, there will be act done in furtherance of such common intention. And as this section is not in itself an offence, there must be some criminal act which is done. So now, fourth requisite which is common intention must be shared between several persons, like 2 or more persons. And lastly, such persons must have done act which is decided or pre-planned by them as per their intention. So in this case, you can find all these requisites as per the section.
Why, according to the High Court, this provision was not applicable?
It was not mentioned clearly in the facture about that thing, but I would state that it should be applicable because Kevin had intention to use acid. Because first of all, he is a prudent and reasonable man who can think what are the natural and probable consequences of using bottle of acid to regular Jessica. Then nextly, he could have used like water instead of acid in that bottle. Second, thirdly, he did not even object when Martin said that let's use acid. And now, in various cases like Sachin Jana and Anandraj was the state of West Bengal, Jain was the state of Maharashtra, Anandraj was the state of Bihar. It was said that the common intention can be formed even at that particular moment, the spur of the moment. It need not be pre-planned or what we can say pre-immediate. Then it was also said that
You
direct.
can go to the next issue.
So the issue 4 is basically by transferring the case for consideration of enhancement of compensation and acquitting the accused, is it setting a precedent for blood money in the country? So for dealing with this issue, I would like to explain what is the concept of blood money. So in ancient India, before the judicial reforms which were brought by royal listing, it was practiced in India like blood money. It was in Muslim law, it was also found in ancient Germanic, Japanese culture. So the concept is, if any offender hurts any person or commits or causes death, then that offender needs to compensate the victim or the victim's family. So it was eye for an eye or vengeance kind of thing. But here we should look at the case from the perspective of it being a criminal liability case rather than a blood money case. So the concept of blood money was very much biased considering the gender of the person, religion, or at what location it was committed, or even the situation. But criminal liability is not biased, it is equal for everyone. It depends upon the facts and circumstances of the case. Nextly, the unintentional acts were compensation was given for unintentional acts in blood money. But in criminal liability, we look at the mens rea, actresses, everything while giving compensation. Additionally, the state is the prosecutor in criminal liability cases. But in blood money, the victim or victim's family is the one who is claiming the compensation directly from the person who has committed the crime. Now, it is also held that blood money flourishes, or we can say it promotes crime for the people who are
But
dead.
we can go to the next issue.
The next issue is whether the state is justified in its plea to add Section 366 of IPC. So Section 366 of IPC deals with abduction for the purposes of forcing the woman to marry that man. So in this case, in this issue, it is humbly submitted that the state is justified to add Section 366 of IPC for several reasons. Firstly, there are a few offences which are punishable even at the stage of attempt. Here, Martin, Kevin and Joseph and Rob, they committed the crime, but it did not get completed because of the chaos which happened later, like acid being thrown on Jessica. And second reason, it would have been difficult for the victim, that is Jessica, to narrate the incident because of the great shock or terror she might be in after all these incidents happening. So how would she narrate it to parents or police? So that would be difficult for the police to add appropriate sections or charges. So, and lastly, these situational faults cannot be a reason for not adding the sections or charges at this stage. Justice should be served to the person when it is necessity. So here in this case there is a necessity. And even in the case of State versus Jitendra 2023, it was held that there is no bar against conducting further investigation under Section 173 clause subsection 8 of CRPC. So further investigation can be done even at any stage, be it appellate stage or first initial stage. So because of some several faults which happened with lot of
We can go to the next.
that's it, my lord. I would like to proceed with the prayer. Therefore, in the lines of facts of the case issued today, arguments advanced and the authority cited, the counsel for the appellant humbly submit complete praise before the honorable court as per the principles of natural justice, equity and good conscience to kindly declare that the appeal is maintainable. Second, to enhance compensation for the victim's medical expenses and other injuries. Third, to set aside the acquittal order held by the honorable high court, which was in the favor of the respondent. Fourthly, to convict the respondent under the charges of Section 326A, Section 354D of IPC. Fifth, to add the charges of Section 366 of IPC to convict the accused. Seventh, to pass any order that it may deem fit in favor of appellant in the light of equity, justice and good conduct. Much ado.
You have fixed an application for this. Obviously, the commission to once of that. In the case of State of Kerala versus Kevin, council will be covering issue number 2 and issue number 1, and my co-counsel will be covering issue number 3 and 4. Issue number 1: whether Kevin had committed an offence under section 326A of common intention. It is submitted, my lordship, that the act of the acid case was not in the furtherance of common intention as in light as of state fact. It has been made clear that Kevin was devoid of any such intention. If we talk about the lack of voluntary action, actus reus, the concept of actus reus necessitates a voluntary commission of an unlawful act. Here, however, the evidence presented by the prosecution has failed to prove that there was any actus reus or voluntary act done by the Kevin. Even absence of common intention, which mens rea, the prosecution relies on section 34 of the IPC, premised on the principle of common intention. Here, a closer examination reveals a stark absence of the required mens rea among the accused. There existed no pre-planned or shared criminal objective among Kevin. If we talk about the Kevin constantly expressed his disapproval of any harm coming to Jessica. He has earlier stated that no harm should be taken place if we are using that acid. That this was the condition before accepting the situation there. And even in Mehboob Shah, which is King Emperor, page number 13, para number 15, which we had mentioned, 1945, it was clear that the lordship that the common intention within the meaning of section implies a pre-arranged plan, and to convict the accused of an offence applying the section, it should be proved that the criminal, According to you, it was only a threat to be done and not the actual act.
Yes, my lordship. Because there was no presence of mens rea, no action of plan. And here,
So when you carry acid with you, there was no mens rea.
mens rea was there just to threaten them.
So if was mens rea was there, then you cannot fulfilling the condition of 326A.
There is a difference, my lordship, because in the mens rea,
Because in threatening there cannot be a mens rea. Mens rea will come when there is harm is to be done, or actually harm is to be planned to be done.
but it was already planned, my lordship, that no harm should be taken place. It was just to threaten her, so that he could marry her, taking her to the church.
You can go to the next one.
Section 326A of IPC. Section 326A of the IPC pertains to the voluntary causing of grievous hurt. The section itself says the voluntary grievous hurt which accused can be applied here. However, Kevin's action do not align with the parameters designated under this provision. There exists no evidence from the prosecution side Kevin voluntarily causing harm, because Martin has threatened, and because of the Martin, that his friend accused number 2, because of that incident has took place. So there was no intention or no evidence proved by the prosecution, as the burden of proof relies on them.
Can 326B be applied in your case?
No, my lord.
Why? What is the difference between 326A and 326B?
Apologies, my lordship, but I want to complete with that 326A. It itself says that voluntary causing of grievous hurt. Here, if there is no mens rea, then how come this section will be applied here? Furthermore, if we moving forward to the issue number 2, whether Kevin had committed an offence under section 354B of IPC. Lack of stalking behavior, the extent of section 354D of the IPC resolved around the prohibition of stalking behavior. It is characterized by persistent and unwelcome pursuit. Contrary to the prosecution assertion, Kevin attempts to communicate with Jessica and were driven by genuine affection and a desire to establish a meaningful relationship. He was in a serious feelings towards her. Moving forward, reasonable and justification. If we talk about crucially, section 354D of the ITC provides a safeguard against wrongful prosecution by stipulating that conduct shall not amount to stalking if it is reasonable and justified in the particular circumstances. In the case at hand, Kevin's actions were not only reasonable but also justified by the circumstances surrounding.
Here he was just trying to understand the situation which Jessica was dealing with, because when he proposed her, she would have resigned at that moment only, but she didn't do that. She just said, you can ask my parents, you can talk to my parents. We can assume that she might have feelings towards Kevin also. Their lack of malice of Kevin, far from exhibiting malicious intent, Kevin efforts to approach Jessica's parents with a marriage proposal and underscores his genuine intention and respect for Jessica.
And then move to the next point.
The further point, the further issue will be delineation.
Particularly Kevin, my client, the accused here, my lordship, as feeling towards Jessica on her 18th birthday, he gives Jessica the watch. Jessica accepts that. He develops the feeling and he proposes Jessica for marriage, not only to have some relationship but pure marriage. After hearing this, Jessica never denies that. She says, please speak to my parents. After he speaks to her parents deny that, and her parents threatened him and threatened Jessica, saying that they would bar her study if she goes for this relationship. They also beat my client, Kevin. Kevin further approaches three of the friends, Martin, Joseph, and John. Martin is like 45 years late, like father figure for the Kevin. And Kevin discussed this issue with the Martin. Martin felt very sad being a fatherly figure, and he suggested, saying that seeing her alone, because he approached her home, and parents would allow him to meet Jessica. So when she is alone, just take that opportunity and approach her and we will convince her for the marriage. And Martin suggested that we will take an acid water just to threaten her, but Kevin was reluctant for that. However, Martin then said that we will just use this as a threat. Kevin further specifically said that no harm should be done to Jessica, no matter what, because he intends to marry him. So this is the background, my lord. Section 4 has convicted my client Kevin under Section 326A, Red Will 34 of the RPC, Section 354D for this copy, and that's my lordship. However, when my client approached High Court has acquitted all this accused and freed my client from all these charges. Now, the state has appealed the Supreme Court, saying that they want to have all these charges again, 326A 34, 354D stalking, as well as state further, even they had the opportunity, they never added this charge, but now they, in the appeal, they are saying that they wanted to add the charge of 366, which is without transaction. So, for this, the issue which has been framed from this side, whether there exists common intention between Kevin and Martin as the Section 34 of the IPC. The High Court has rightly given the acquittal for my lordship, as because there is no common intention seen here. Just reading the provision of Section 34 of IPC, my lordship, acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of common intention of all, each of such persons is liable for that act in the same manner as if it were done by him. Now, coming to the principle of common intention, the council begins here that the principle of common intention here is not met, as seen from the facts of the proposition mentioned in page number 1 and page number 2, that and also as the council presented that Kevin was since start having a good intention of marrying Jessica. There was no intention from the Kevin side. Also, Kevin was reluctant when Martin proposed this plan for using of acid. Also, Kevin patiently waited Jessica turning 18 and asked for the marriage proposal, not only to her but he went to her parents as well. So there was no intention seen. Also, repeatedly he was telling that there should be no harm caused to Jessica, no matter what, as he was intending her to marry. Now, referring to one of the cases, my lordship, in that case, the state of Andhra Pradesh versus Ramagarupa, Pune and others. This case I am referring not for the fact but for the principle where the invoking of Section 34 was done. So in this case, Supreme Court of India discussed the requirement of invoking Section 34 of IPC, which deals with the act done by several persons in furtherance of common intention. The court emphasized that the section 34 to apply, there must be a proof beyond the reasonable doubt of a pre-arranged plan. Here, my lordship, as the burden of proof lies at the appellant's side, they have not established any proof of the common intention of my client, which is Kevin. Because from the known fact, client did not have any ill intention from the start, my lordship. Also, the case law includes the argument that mere presence of multiple individuals involved in an act does not automatically imply that the existence of common
Go to
intention.
the next one.
Yes, my lordship. The next point here is whether, as the state appealed for the addition of section 366 of IPC, which is objection, my lord. So it is only submitted before the honorable court that the present matter has already been tried before the session court. Magistrate at the time of committing proceeding under the section 209 of CRPC did not charge accused with the section 366. The appellant has an ample opportunity if they wanted to add this charge. They never added this charge. It is further submitted that the High Court, having inherent power to do so, did not find any ground to add the charge under 366 of IPC, my lordship. Also,
Next one.
this is the concluding point for my lordship. Just giving the reference of section 216.
You are supporting the order of the night.
Yes, my lordship.
Thank you.
Can I make a clear knowledge? In the light of the issues raised, argument and laws and authority cited, the counsel for respondent only praised that however the Supreme Court will case to assert Mr. Kevin's consent in the alleged crime that he has fought various hurt and not respectfully discourage the state from seeking to add the additional charge of section 366 of IPC and also to convince High Court's appellate order in the favor of Kevin, which is to my lordship.
For only 2 minutes, sorry.
So, then counsel for respondent stated that they must, they got common intention, they must participate in the same act. But in the case of Mandur Asgori, it was held that even if each one of them is playing their assigned role by doing separate acts or similar or diverse acts, then to that attracts the section 34 of IPC. And next week, when they stated that Kevin was reluctant at first to use the water acid, but at last he agreed to it. That means he had some intention. Even though he had feelings for Jessica, he had also feelings of vengeance because she rejected him for marriage several times, not just once. So he had some malice and he is a reasonable man to know what are the consequences of this act of using a bottle of acid to get a person. And if he claims that he loves Jessica, then why let a person you love like so unconditionally, or why use a deadly substance to better that person? Next week, counsel for respondent stated that they were using bottle of acid just to tell her to marry. So this is actually attacking provisions of section 360, that is abduction for the purpose of marriage. And next week, then they said that he was in love with Jessica. I would say that every relationship needs reciprocation. Even though he had feelings, she did not have. Even the parents were not ready. And even though she did not say clearly that it is a no from my side, we should consider her age factor. Even though she has turned 18, it is still a tender age where children might not be able to make the decisions properly regarding marriage and all these. I would give me permit just a minute.
No, sir, you can.
Thank you. 01 and 09. Now, with the kind permission of your Lordship, I invite the next team to start. I seek permission of the court clerk to start. The next team, please come forward. Team 14, 14 and 15, 15. Appellant is 14 and respondent 15. Please take your positions. Please submit the necessary documents. Check your mic. Team 15, please be quick.
There are real answers for the applicant. And for the sake of brevity and to avoid basically the type of the code, should I directly proceed with the issue of the case or should I decide the facts of the case again? And you decide which you want, which way you want to do. We go to the issue of as the logical, the audience, you don't go by what I want. The facts of the case here suggests that the applicant, who is an 18-year-old girl studying in 12th standard, belongs to a lower middle class family where the father is a clerk with a private firm. And Kevin, the primary accused in this case, is the math teacher of Jessica, who has proposed Jessica for marriage on the second occasion. First, he has offered a gift to the appellant on her birthday, which she accepted in good faith, not knowing the actual intent of Kevin giving him that expensive watch. Here it is to be noted that she belongs to a lower middle class family, and that was the reason. The reason from the beginning was malicious. Because Kevin, knowing that she belongs to a lower middle class family, had gifted him an expensive watch which has been expressly mentioned in the facts of the case and for which the appellant was not aware of. Which is again very clear in the subsequent events which has happened. Jessica, knowing that he is the math teacher of Jessica, she knew that he is her math teacher. So she took a diplomatic response by directing her to her parents as the case should be, as the scenario, as the practice generally should be. By not bluntly saying a no, fearing the fact that there might be some consequences with context to her education or with context to hurting of the fragile ego of the respondent, which has subsequently happened, where on multiple instances in diverse methods, when the petitioner and her family, they have adopted diverse methods to explain the accused that the said intent is not possible. He
enraged in these feelings of rejection, has approached his friends, Martin and
You can go to the sections. How much ingredients of section are satisfied in this case?
Yes, Your Honor. The primary ingredient, as per my issue number 2, 3 and 4, in the issue number 2, as on the page number 10 of the memorial, there is a additional section we are proposing, which is section 366 of IPC. Here, Kevin had an intention of section 366.
Why your officers did not invoke this section in the first stage itself?
Your Honor, this was not invoked before, since Jessica at that time has suffered some previous injuries and she was not in the state of the mind to disclose this fact, which lately recollected after she underwent certain 10 to 15 surgeries, and when she came down in a state of mind again, she recalled the complete instance, and that is when she realized that the sequence of events have occurred in which there are certain elements which are found to be fitting in the sections of 366 IPC, where the section itself says it is attempting of a woman to compel marriage. Here, all the 4 accused have dragged the victim to a car, and the intention was to get her married to the primary accused. So the ingredients of this section are clearly getting fulfilled in this case here.
You can go to your next.
My next issue is whether the accused is liable for life imprisonment under section 326 read with section 34 of IPC and section 354 of IPC. Yes, Your Honor, all these sections do apply in the present case, because primarily the primary accused had the knowledge of acid causing likely harm if handled or mishandled in a particular manner. So for any crime to happen, there are generally 4 stages. It is the plan, preparation, attempt, and the act. So all the 4 stages of a crime have occurred in all the 3 sections, fulfilling their ingredients. So in 326A, it states that the act is already committed. There is a acid attack which has happened, and all the accused have the knowledge and the harm it would likely cause to the victim. So in section 34 along with this can be invoked. Section 34 of IPC along with this can be invoked because there was a common intent, there was a pre-planning.
Go to your next point.
So, my next point here is section 354D, which has to deal with stalking, and here the primary ingredient of stalking is upon an express refusal or a disinterest shown by a woman, a man still follows or tries to contact her in various manners by trying to talk to her or contact her by way of phone and internet, etc. All these sections ingredients are fulfilled as the facts of the case clearly show on page number 6, Your Honor, point number 9 in the statement of facts, it reads as, on Jessica's refusal, Martin was carrying the bottle. It is a refusal. At the time they were threatening also. It was an express refusal that time also, as well as prior to that, Jessica has expressly refused after her parents disagreed with the proposal. So in both the manners, parents as well as Jessica herself, the woman herself has shown a disinterest. So clearly the section 354 of 354D of IPC is applicable in this case, Your Honor. Now, with the permission of Your Honor, if section number 4 would be allowed, my co-counsel will continue.
Your Honor, Counsel will seek permission to continue petition number 4. High Court, right? Whether the petitioner is eligible for enhancement of compensation under section 357A of CRPC. Yes, Your Honor, it should be eligible and it should be granted, as in this case it is evident from the fact that the case that the respondent has undergone 10 failed surgeries as she was injured gravely by the permanent deformation of face and the loss of sight. In one eye, in one of the eye, and she belonged to a lower middle class family whose father is a clerk in a private firm, and she herself also takes tuitions in order to support her family with her other two younger sisters. As the income earned by the father is meagerly just not enough for their efficient survival. Hence, in the light of the fact, the Honorable Court may be pleased to enhance the compensation of Rs 350,000 under Section 357A of CRPC. And also to support my argument, I am citing the case as titled as Lakshmi versus Union of India and others, All India Report 2015, Supreme Court 3662. In our opinion, it will be appropriate if the member secretary of the State Legal Service Authority takes up the issue with the state government, so that the orders passed by the court are compiled with a minimum of Rs 3 lakh rupees is made available to each victim of acid attack.
Anything else you want to say?
So I can conclude with my prayer. Highly obliged, sir. It is humbly urged before this honorable court to uphold the conviction of Kevin under section 326A of Indian Penal Code, based on the principle of formal detention as outlined in section 34 of the IPC. It is prayed that, despite of diverse methods being deployed by the petitioner and her family, the accused is committed to continue the function of the act punishable under section 354 of IPC. It is most humble urged this honorable court to be pleased to impose the charge under section 366 of IPC, since the whole event is based upon the abduction of a woman to compel her for marriage. It is prayed before the honorable court to be pleased to enhance the compensation amount under section 357 of CRPC to Rs 350,000 as the act of the accused has led to an irreparable loss caused to the petitioner, and this amount is just enough to facilitate the petitioner with the expense incurred for the multiple surgeries. And also the loss of job of a father who is the breadwinner of the family. And may be pleased to pass any other order to grant any other relief in favor of petitioner which the honorable court may deem fit in the interest of natural justice and equity.
How is natural justice applicable in this case? No, you can't. I have asked her the question.
So natural justice, I think this is an acid attack, sir. The Jessica, we are finding ways to support her family and also to give up the maximum compensation, because this is just not the compensation given here is already 6.5 lakh rupees has been invested. But also, if you look forward, in her future, there is her marriage after her parents, who is there to look after her. So your compensation and all other sections are very much required, because acid attacks are just not other crimes wherein you give compensation or you just give punishment to the accused. Here the victim has to take this all her life. There is no repair. So we call her naturally.
Okay, thank you. That's all from you.
Yes.
Yes.
May please this honorable court, I stand before you not to minimize the tragedy on behalf of Jessica, but to shed the light on the complexity of the case and advocate for a fair and just resolution. Would your lordship appreciate a brief perusal of the facts?
You decide the way you want to
Yes,
do it.
sure, lordship. Honorable court, let us first acknowledge the tragedy Jessica has endured, right? An innocent young woman who was just 18 years old, who has gone through a horrific attack resulting permanent physical and emotional scars. Our heart goes out to her and we acknowledge the suffering she has endured. But it is imperative for us to dwell into nuances that event it has led to. The tragedy. Kevin, an accused, was indeed Jessica's maths teacher, but his intentions were typically misguided. Even though his actions were inappropriate, but they were not malicious in nature. He merely sought to express his feeling towards Jessica. Furthermore, the plan to abduct Jessica and the subsequent acts.
So you express the feeling by throwing acid on somebody who will not.
It was, we have to contain, I understand that was not the way, but here we can see that that was not his intention. His intention was just to clear the acid. Moving on, the plan to abduct Jessica and subsequent acid attacks were not orchestrated by Kevin alone. He was influenced by his ill-advised suggestion of his friends. So in conclusion, I would say, let us try for a
So
resolution.
there was a common intention between you and your friends.
I think there was no common intention. Because for common intention, there are few things which has to be fulfilled. As we can see, as per as section 34 of Indian Penal Code.
But you said he was misguided by his friends. So he very well knew what was that misguidance.
Yes, initially he completely showed his disinterest and he's not okay. He was reluctant and he refused that he should not be the case. It is only for the first they have taken the acid bottle.
But later on he agreed.
Later on he agreed only on one condition, that no harm should have been caused to Jessica.
So after putting acid, how can you expect no harm will be done?
So we can say that for any crime to be confessed, right, there are two things, essential elements. One is actus reus and one is mens rea. So we can say actus reus has been done, but there was no mens rea. There was no guilty intention what Kevin had in his head for Jessica.
You are a maths teacher, a qualified person. Will you not think what will be the repercussion if somebody puts acid on some other person?
Completely ownership. As we can see the facts, we can see on 14th of February, he proposed to Jessica. After that, on 20th Feb, he approached his parents for marriage proposal, wherein Jessica has told him to approach her parents. After that, the act was done on 23rd of March. In this meanwhile, we can even see from the fact that Kevin, who has lost his parents at a very early age and who was living with Marty, when he approached her parents for the marriage proposal, they have rejected it and want Jessica also. So maybe he has just lost his mind and just in front of him, out of revenge, and he was not in complete sound minds. Because of that, he might have been influenced by Marty.
Did you give any evidence to show that he was not of sound mind? Then proceed.
So In the honor, esteemed member of your court, I rise to address the private issues like the case. So, the first and second issues would be dealt by me, and the third and fourth issues would be dealt by my co-counsel. First issue is whether there exists common intention between Kevin and Martin as per as section 34 of Indian Penal Code, which is read along 326 of IPC. 326A. As it is already been told that for any crime to be committed, there is actus reus et mensea. We should not even forget that there is the most fundamental level a criminal law is based around a single phrase, that is actus non facit reum missing and sequela. It means a person to an act which is being done, person is not guilty until and unless his mind is also guilty. We can even see in this case, Kevin did not have any guilty intentions for her. The only intention what he had was only to marry her. And as it was already been identified that initially he was very reluctant about it, but later he said only on condition that there should not be any harm caused to Jessica. Coming to Article 326 of Indian Penal Code, it is whoever voluntarily causing grievous hurt by using acid, etc. We can say in this, according to section 39 of Indian Penal Code, a person is said to cause a defect voluntarily if he caused it, causes intentionally, or he knew it, or he had reason to believe to be likely to cause it. So it is humbly submitted before court that our client did not have any, he did not act voluntarily at first. He had no intention of causing any harm to the victim, and secondarily, he had no reasons to believe that such things can happen unintentionally. Moreover, our client did not commit the crime any such act. Hence, Kevin cannot be charged under section 34, and hence cannot be. Also, I can cite a case law, Pandurang versus State of Hyderabad, in which the court had in mind the ultimate act done in furtherance of common intention. Here, in this case, we can see the ultimate act in this case is acid, throwing of acid attack. It was not in furtherance of common intention, as in light of stated fact, it has been made clear that Kevin was devoid of any such intention. He made it very clear the acid bottle is just a tool for threatening her and not further to harm. And so because of that, we cannot say there was a common intention. The other thing what I want to mention is common intention has almost evaporated as soon as Martin opened the bottle of acid. It was so act of Martin, and Kevin was not responsible for the act of Martin. And Kevin played no important role into it. I would like to address the opponent even mentioned there was a meeting of minds. Here we can say there was no meeting of minds because the common idea what they had initially while planning the case was not throwing acid onto her. So I will continue with that way. If Honorable Lordship permits, we would like to move to the second issue. Second issue is about whether Kevin committed an offence under section 354D of Indian Penal Code. Your Honor, there are few things which has to be fulfilled for the stalking to happen, but we can there is an exception. Any conduct on part of respondent trying to talk to Jessica doesn't amount to stalking, as it is covered in clause 3 of proviso of subsection 1. Whether there exists common intention between Kevin and Martin, as I'm so sorry, sir. Subsection 1, which says that in the particular circumstances, such conduct was reasonable and justified. Moreover, even the ingredients of Martin's definition, such as disinterest and foster personal interactions, may not be relevant in such scenario. I would again counteract those things that she had expressed her disinterest. I would like to say, my lord, that initially she did not support her disinterest, but later on she has clearly mentioned after some emails that she is not interested. And I would say once she has shown her disinterest, that doesn't matter it was shown in the initial day or in the later on stage, but the disinterest was being shown. So it is humbly submitted before the Honorable Court in light of the fact of the case that girl never refused his after the match.
Next point.
Sir, the issue number 3 and 4 is used in the court.
Your also request to lay this start from where you want to consider. I don't think. I believe issue number 4, whether the state is justified for seeking permission for addition of charge under section 366 of the IPC. It is humbly submitted before the Honorable Court that the present matter has already been tried before the Session Court. The magistrate, at the time of committal proceeding under section 209 of Criminal Procedure Code, did not charge the accused with the section 366 of the Indian Penal Code. And again, I want to read 362 Indian Penal Code of Indian Penal Code, the definition of abduct. Whoever by force, compels, or by any decisive means induces any person to go from any place is said to abduct that person. I think 362 clearly says that when a person take from one place to another, that time abduct was occurred. But Jessica has not been taken from one place to another. That's why I think the implementation of section 366 is invalid on my client.
Next one.
Your Lordship, the council requests to move to prayer. Highly organized. In the light of the issue raised, argument advanced and authorities cited, the counsel for respondent humbly prays that the Honorable Supreme Court be pleased to declare that Mr. Jain is not guilty of the crime of causing serious hurt by use of acid and stopping. Second, to declare the permission shall not be given to the state to add a charge of section 366 of Indian Penal Code against the accused. Third, to declare that the Honorable Court acquittal order of Mr. Jain should be reserved. And pass in order that this Honorable Court may think it in the interest of justice, equity, and good conscience, and for this act of kindness, the counsels for the respondent as an duty bound shall ever be paid. Thank you, my Lord.
Your Honor, if it may be allowed, I humbly pray before Your Honor to allow me a chance to counter the verbal argument submitted by the
Just 1 minute.
yes, sir.
I'll give you only 1 minute.
That is enough for me, Your Honor. Thank you. Thank you. Your Honor, there are 2 occasions in which the verbal submission made by the opposite counsel needs to be taken on record. Is that the first is the counsel for the respondent has stated, and it is undisputed fact from the appellant side, that the act was done as a revenge. So, sir, it is a clear-cut intention of
Next point.
the second act which is undisputed is that there was an express refusal by the victim, and still the accused has done the
Next point.
Your Honor, for section 326, 326A, if the respondent did not have the intention of causing hurt to the victim whom he loved, he could have used some other substance instead of the original acid.
Next point. That's all.
And just a concluding statement, the counsel for the respondent has emphasized those words at the first and initially multiple times in her proceeding. which clearly states the men's year and actress year, and both are
Next point.
Your Honor, that is all.
Thank you.
Thank you, team 14 and 15. With that, we conclude the semi-finals. For brilliant deliberations were indeed an academic feast and an absolute delight to watch. Thank you all semi-finalists for outstanding performances. The path to success is winding and steep and full of challenges, but it is the courage to continue that counts. It is not just about achieving your goals, but also enjoying the journey throughout and learning all the way. The finalists will be announced in 5 minutes. Be patient and calm. Please don't leave the courtroom. It'll just take 5 minutes.